Hey there, this is Attorney Dan with Attorney Stephen Liu. We've been working on a couple of estate planning cases together over the last couple of months, and I thought I'd have Stephen here come and chat with us about estate planning and what he's experienced over his 20 years of practice. So thanks for joining us.
Yeah, my pleasure.
Yeah, so let's kind of get right into it. Let's talk about maybe some of the mistakes people have made, whether it's not planning or maybe even do it themselves, right? You have one, right? Not planning, where you had the grandmother and the mother,
Yeah,
right? But maybe like, oh man, I wish they had seen an attorney
right.
before all this went down.
I mean, one of the simplest things is they go through it. Let's say you even use the legal docs or whatever, and you do all that work, and let's say you even fill out and you draft, but it wasn't ever executed. I mean, that's like this, right? Like they even went through it. A will in California needs to be witnessed by two disinterested witnesses. Something simple as that. So you sign the will. Great, put it away. But actually it's not valid because it wasn't witnessed by two disinterested witnesses. So something as simple as that could be a huge issue, even if you go through one of the softwares, right? The other one is same thing with trust, right? Like all the good intentions, all the work doesn't mean anything if it's not executed. So they have this document, good or bad, not commenting on that. It wasn't even signed or wasn't notarized, right? Best practice also to have it notarized. So some people have it signed. Would you say, is it okay? It's arguable that it could be, but if you have any dispute over it, authentic, you don't have backup that it was notarized, right?
Yeah.
It was signed. Well, I don't know. You were brothers like you. She was in a nursing home. She had dementia. Now we start having all these questions, and we take this to court.
Yeah.
Was it notarized or wasn't notarized?
Yeah.
Well, where's the presumption?
Yeah.
The presumption is going to be that maybe she did have dementia.
Yeah.
Versus where it's notarized, the presumption is it's valid unless you can show me that it wasn't valid.
Yeah.
So those are some of the things that you don't consider. That's what keeps us up at night. Is those things, and we want to make sure that that's done properly.
I remember I had a case a couple of years ago, and they came to me for a estate plan, and they actually went to their financial advisor or planner for get theirs done, but they never completed. Like you said, like half the documents weren't signed. And this is not complete, right? So luckily they came to me, but they're both still alive, and we got it all squared away. So I guess that's the fortunate part of our industry. There's like lots of people selling living trusts and estate plans. But I think one of the big advantages of working with attorneys like us is that we'll get you to the end, right? We'll send out the notaries that are experienced, right? And we've sat through signing ceremonies, right? Where, we busted out our own, we've both acted as notaries before, and we've stamped everything, but at least the clients have the confidence and peace of mind. I think that's so important too, is like they have the peace of mind that what they're signing is full and complete estate plan that they know that's going to carry out on their wishes. I did this kind of another story too. Someone I knew, he did it on his own DIY, signed everything, but for him, it's always like, hey, I'm not sure if I did it correctly. So it's always in the back of his, just like messing with his head, which is like maybe the worst thing you can have, but like, and then he may not care, he's dead, right? So he may not care later, but his heirs is going to matter to them when. And
it's like a ticking time bomb that you don't, I think that's what you pay for a lawyer, is the lawyer goes, you're good, right? We got it. The other thing is properly titling everything, right?
Yeah.
You can put together, even if the trust is fully executed, proper, but you haven't properly put the house in it, right? Or you haven't properly titled your assets in it, then it's a great empty trust that manages nothing.
Yeah. And I think that's one of the top 3 mistakes I've seen as well is titling, is they'll sign everything, especially do-yourself contacts. And even the do-yourself instructions will tell you, like, you got to remember, put it into the trust, but life gets in the way. You don't do this all the time. Sure. And the analogy I like to use is like the living trust is like a car, right? And it's not a collector's car. It's something that gets you from A to B. But if you don't put gas in the car, then it's not worth anything to you. So putting gas in the car is like putting your house in the trust, or putting your financial accounts in the trust, or any particular significant assets that you want to be distributed in terms of trust. So it's very important. It's like equally as important as just doing it itself, but yes, you got to fund the trust to make it effective as you want it.
Yeah, absolutely. That's a good analogy.
Yeah.